Thank you so much for staying with us. And that's our first discussion this morning. Thursday was when the Supreme Court affirmed President Bola Tinubu of the APC as a valid winner of the presidential election that held in the country on February 25. The Apex Court, in its lead judgment that was prepared and read by Justice Nyang Okoro, held that there was no merit in the petition filed to nullify the outcome of the election by former president and candidate of former vice president and the candidate of the PDP, Alhaji Atiku Abubakar. Let's have this conversation this morning with Mr. Wahab Shitu, who is a senior advocate of Nigeria. Thank you for joining us this morning.
My pleasure. Two seniors.
Yeah, of course. We have to call them as they are. And Mr. Yinka Olumide Fushika, also a senior advocate of Nigeria. Thank you for joining us this morning.
Thank you for having me.
Because I don't know whether we say seniors advocates of Nigeria or senior
No, senior advocates of Nigeria.
I'm not senior advocate of Nigeria's, because we always SAS. Don't even. Thank you for joining us. So, of course, needless to say, there's been back and forth about whether or not the judgment answered the questions or dealt with the issues. What's your own take, first of all?
Well, that's the judgment. And that's, as they say, the Apex Court. From there, you go nowhere.
It's over.
It's over. And that's the system that we have put in place for conflict resolution in Nigeria. It's been pronounced upon. And I think everybody should just move on at this stage. And 4 years is just, it's in fact less than 4 years now. I mean, they should go and prepare again for the next round. You know, right now, that's the president of Nigeria. We should just, move on to it. And I don't think Nigerians should. I do understand that a lot of people are disappointed when there's a contest. You know, even as simple as football game. You know, I'm a football fan. I support both locally here and outside the country. When my team loses, I mean, there's that sad, sad taste in the mouth. You know, but just you can't change anything.
Yeah, but what I find interesting, for which reason I think this conversation is coming on, is that yes, it's a known thing that there will be winners and losers, but the sentiments, the emotions that are attached to it, to further whittle down the trust quotient, so to speak, of our systems. I think that's perhaps the issue, coming as a result of the commentaries coming from some interested parties on either side of the divide.
Yeah, well, we have to allow the commentaries. It's a free society. Without commentaries, we can't be. Where would we be? It's freedom of speech for everybody. We've had a very, turbulent recent past, and the last election was quite fractious, in the sense that it divided Nigeria, very seriously. And there were issues also raised, that made people agitated. And you know that we have a problem in the country. People are looking for solutions. Some believe that this is the way to go to solving it. Some other believe that this is the way to go to solving it. I believe, for instance, that, what was on offer was not even a solution. Personally, I think that, and I hope I'm permitted to express it on here, that I think that our problem requires a revolutionary, resolution, which what was on offer during the last election was just one saying, okay, all they were saying is, I can run it better, this rotten system, I can run it better, this is the way they are running it, I can run the rotten system better, and so on. That was what was on offer. And people looked at all the candidates and then said, okay, we'll go with this, we'll go with that other one. The outcome has been disappointing for some. It has been good for some other persons. It's understandable that people are, who didn't get what they wanted from the outcome of the results will be disappointed. Some people will be disappointed at the way the processes went. Even the Supreme Court said, in that judgment, that the failure of this IREV, whatever, contributed to
where we are.
What you are talking about, the deficiency or the loss or the erosion of public trust in the system or in the process that resulted in the outcome of the election. The Supreme Court was not blind to that, But really, you have three organs of government: basic level, primary school civics, executive executes, the legislative arm makes laws, and then the judiciary interprets. INEC really belongs to the executive arms of government. So if INEC makes regulation, what the Supreme Court is to interpret is the law made by the National Assembly. It's not the one that you cannot be executing and making laws for yourself. So if INEC makes regulations for itself, it cannot supersede the law made by the National Assembly. It's so simple, basic.
Yeah, but as basic as that sound, I mean...
That doesn't mean, and I've expressed this view. If, for instance, in my family, I say to my children, or myself and my wife, we decide that, okay, we are all going to be eating. Nobody should take your food to the room or anywhere else other than eat dining table. And I'm enforcing it as the head of the family. Then one day I wake up and I take my food and I then say that I'm not banned by my own rule. And that's not the way to organize society. So INEC has its own blame. If you have come up with regulations and say this is the way things should go, and you enforce it on the people you are regulating, you, the regulator, should also abide because by your own rules. Even if we say it doesn't take the level of an act of parliament so I'm sure they've learned from this and they've seen the effect on the outcome of the election. People don't, a section of the country or a section of our people believe something underhand went on, even when something may not have gone wrong.
Okay.
So that's a lesson to be learned. Obey your own rules. When you make the rules, enforce it. Don't say, oh, I'm banned. I can enforce it on others, but I'm above the law.
Okay. Mr. Shitu, this whole matter of us now leaving the responsibility of determining who wins elections to the courts, do you think that is where we want to be? Because it seems now that every election cycle, it is the courts that determine who wins, not INEC, not the people.
Thank you. Obviously, that is an anomaly. In a normal situation, the voice of the people should determine the outcome of elections. When you call upon the judiciary to adjudicate on the outcome of an election, it is an aberration. That is not the primary function of the judice. As a matter of fact, we are imposing some kind of heavier burden on the judiciary. And that is why we should appreciate what the judiciary has done, in spite of the fact that it is carrying out a responsibility that ought to primarily not rest on its shoulders. Under the normal circumstances, democracy ought to reflect the will of the people as expressed through the ballot box. In a free, fair, and peaceful election.
Did you have to add the word peaceful?
Yes. Because those are the indices, really, that must be in place before you can say the outcome is credible. It must be credible, it must be free, it must be fair, it must be peaceful. As expressed by the people. But when there's a dispute, when people feel aggrieved about the outcome, of course the only other constitutional option available is to approach the court. And if you then approach the court and the outcome is now decided as it has now been decided, then all the actors must be prepared
to accept the decision of
the court.
Supreme Court.
And then in accepting the outcome, what do you expect the judges to do? The judges, they were not involved in all the polling judges. They were not there. And that is why, in appreciating what the judges has done, you must also recognize how the judges functions. How do the judges function? They function on the basis of facts, as pleaded and proved. They function on the basis of not sentiments.
Sorry, even if there are some facts that they are aware of, so if the lawyers do not present those facts, there's no way they're going to pronounce judgment because they know.
How do you want to?
It's only based on what they are presented with.
Facts presented, pleaded in our own parlance.
Lingo.
You must plead those facts. And then you must also lead evidence in proof of what you have pleaded. So, in undertaking a critique of any judgment as handed down by the judges, what a rational person should do is not to rely on beer parlor gossips. It's not to rely on sentiments. It's not to rely on public opinion, which is kilometers away from the law. Is to rely on what I will call justification. You put the judgment under searchlight and see whether the conclusion satisfies the requirement of justification. And if you look at what the Supreme Court has handed down on all the issues, there's no way you can fault the reasoning. We have the law, for instance, in an electoral contest, for instance. It's guided by the Constitution. It's guided by the Electoral Act. It's guided by, certain, regulations as handed down by INEC pursuant to the Electoral Act. And I can say this for free. In this dispensation, I think I prosecuted about 5 or 6 election petitions up to the Court of Appeal. And I say it for free, victoriously. Because I was representing the respondents, those who were declared winner. So I can tell you for free that is the task of proving that an election is marred by malpractices or void of or some other considerations. It's Herculean. Herculean. There are 4, 3, 4, 5 grounds on which you can void an election. It's either you say that the person who is declared the winner did not score the majority of lawful votes.
Okay.
And second, or you say that the election is marred by
violence,
malpractices.
Okay.
Or it did not conform with something, was not conducted in substantial compliance with the Electoral Act. Or you say that at the time of the election, the candidate was not qualified to contest the election. Those are some of the grounds.
But should you not have said that before the election?
Well, it depends on if you say if somebody is presented by a political party that's having been qualified to contest the election, and you have evidence at your disposal that the person
is not qualified.
It's not qualified either by. Not only qualification can arise as a result of maybe if you say, for instance, the person has been convicted, or the certificates that he presented for election was forged, and you have evidence. Of course, before you can even assert all of this, for instance, you are talking of forgery, for instance. It's something that is subject to scientific proof. You must have a forensic report to show that the particular report. I mean, yes, so it's very peculiar. So asking, we are talking law now. We are not talking sentiment. We are not talking public opinion. We are not indulging in law politics. I mean, conversation. The judgment that's handed down by the Supreme Court cannot be faulted. No one can fault it.
But of course, you know that lawyers are saying, some lawyers are still crying wolf.
Can we what?
They are still crying wolf.
They are crying wolf over what? For instance, if you are alleging forgery, do you present fresh evidence
at the Supreme Court?
At the level of the Supreme Court? It doesn't make. It defies logic. Because the Electoral Act under Section 285, subsection 5(6) prescribe a maximum limit of 180 days to adjudicate over election dispute. For instance, if an election result is declared, you have 21 days to present your petition. That's the law. Now, if you do not present your petition within 21 days, say you present it with 22 days after the election result, you are shut out.
Okay, let me continue.
You are shut out, and that's the rules. And all the lawyers know
Everybody
this.
knows. Okay, well, Mr. Lumide-Fushika, let me ask you this. One of the statements in that judgment of the Supreme Court that I have not gotten over is the one where the Supreme Court says there has to be an end to litigation. And it just raises one thing in my mind, that it is the judiciary that is putting the judiciary under the microscope. That judgment says, look, this particular issue, one of the, pleas, right? Is that the language? One of the pleadings, is it pleadings or one of those issues raised?
You're trying to become a lawyer, huh?
Just use allegation.
Okay, yeah.
I understand what you're saying.
So one of the cases, whatever it is that is being, asked for, had been decided in May 2023, and to have to re-litigate it, and the Supreme Court says no, it's not the way to go. What do you make of that scenario? Should it have happened? Isn't it still the lawyers that are doing that to the law?
Well, my understanding was that the lawyers for one of the side, or the appellant, believed they got some fresh evidence, after that the evidence was not available to them at the time they were conducting or filing their papers at the Court of Appeal and conducting the case, and that there is a rule in the Supreme Court rules that permit them to bring the fresh evidence in for the Supreme Court to consider it at that level. Let's understand that these are also very well trained lawyers on both sides, so they wouldn't. You wouldn't expect them to. They are not foolish. They are not stupid. They know the law. But as lawyers, there are some things that we appreciate more than somebody who is not trained in the law, but which is also for the benefit of the society. That statement you said was made by the Supreme Court. See, when at that level, at the level of the Supreme Court, even at the trial court level, but especially at the level of the Supreme Court is a policy court. And what do I mean by policy? A case is not determined, even though the parties is a decision, the parties before it decides, what is actually in dispute in that case. But it's also a decision, that speaks to other cases that are yet to come. In other words, you should when you read it, you should know what the law will say in similar circumstances if you come in future. It is not that you say A between Mr. Ojo and Mr. Ibu, same facts. and then you say not A, when it is, you know, Mrs.
A similar case.
Similar situation.
Scenario.
Similar You know, when you see the symbol of justice and you walk around it all the time, you see it, you don't know what it means. You know, the blindfolded maiden carrying a scale and then that sword. You know, what it's telling you is that the blindfolded maiden is the judge. You know, he doesn't know you. He doesn't know appellant. He doesn't know respondent. He doesn't know defendant. He doesn't know. That scale is carrying. Is, you know, put your evidence, both sides, put your evidence, the evidence you have, put it on one side. The other person, put it where the thing tilts. Blindly, he's not looking. Once the thing tilts to one side, that's where the justice of the case is. And it will always be in every situation, irrespective of who the parties are. Now, what they were saying, even though, you know, if the Supreme Court allowed it, if the Supreme Court allowed what they were saying in this particular instance, you know, as a practitioner, I know that it would have been a disaster. It would create a disastrous effect, repercussion, outcome. So that if you feel that, oh, we've been done injustice in this situation, you know, it may be justice for the society on the long run. You may have a sense of injustice. Because if it is not done, the way we have it now, we have 3 levels, generally. Sometimes 4, if you start from the magistrate, but let's start from the trial court. You go to the trial court, that's the high court, a decision is rendered. You go to the Court of Appeal on the same matter, a decision is rendered. You go to the Supreme Court, a decision is rendered. That's supposed to be the end of it. Now, you are saying, well, at the high court, I didn't have this evidence. You may be right in saying you didn't have the evidence at that time, and you are entitled to now bring the evidence at the Court of Appeal or at the Supreme Court. You say there's a rule that says you can bring it. Now, look at the implication of it. If at that level, at the level of the Supreme Court, that's where you now want to call witnesses or you now want to bring fresh evidence, and the Supreme Court in this case allows it, it has set a precedent. So it goes beyond this particular case. What that is telling litigants is that you can compete and refuse, or well, not refuse, you know, for one reason you don't have your evidence at the lower court. Then when you get to the Supreme Court, you come and present it. It goes beyond this particular case. The implication of that is that everybody, every litigant, because we don't never give up. Once judgment is given, we'll go looking for fresh evidence that we'll present at maybe Court of Appeal at the Supreme Court. There will never be an end to it. So what the Supreme Court is simply saying is that beyond this case, you may, you know, be agitated, concerned. Oh, why won't you take it? Why won't you take it? If we take it, it has implications beyond this particular case. You are going to bring the whole system down, destroy it. We can't do it. And for me, I think it's reasonable. Right now, as we are speaking, and if you've been following the retirement speeches of some of the judges and so on and so forth, unlike my, you know, good friend here, I'm not too much into these election litigation issues. We have other matters that we do. Most of the cases that are not election matters are held up at the Supreme Court. Some are 20 years old. Appeals of 15, 18 years old, and all that. The priority, because of the urgency, election cases and so on and so forth. And then you now want to open this window. Then everybody will come and say, we have new evidence, we have new evidence, we have new evidence. The system is already unworkable. It's not working. You now want to introduce this again to it. There must be an end to litigation. That's the meaning.
Part of the cases raised, where I think the particular one where the Supreme Court said there must be an end to litigation, is one where they said that they had already decided, and it had to do with double nomination. The issue of double nomination
concerning the vice president.
It's not that the lawyers don't know, is it? So why bring the same? In fact, I think that is what, okay, the justices said, for us to sit down now and talk about this when this man, on and on, what I was looking for is to tell you, if you read the judgment of the lower court, they mention that the Supreme Court has settled this matter, and that should have been the end.
Yeah, the Supreme Court was making reference to issue estupend. Once an issue has been adjudicated upon, that issue is
finished.
You don't raise the issue again. And like the learned senior advocate mentioned, it is not for us to sit down here and condemn lawyers.
No, we just want to understand.
I'm just saying. I'm just laying the foundation.
Because I mean, if what the Supreme Court said, look, this shouldn't have even come to the court in the first place.
That is the conclusion reached by the Supreme Court, and I believe everybody is bound by that conclusion, including the lawyers on both sides. But that's not to say they are not competent, or they ought not. They ought to have known. In a contest, you advocate what you believe in, believing that maybe there could be a departure. You know, but now we know that once the Supreme Court has pronounced on a matter, it is conclusive. It's the final court. We don't litigate an issue that has been pronounced upon by the highest court of the land. That if you start that kind of process, there will not be an end to it. An issue has been resolved, it is resolved conclusively. And that's what the Supreme Court has alluded to. And that is the way the justices saw the issue and resolved it. But that is not to say that those who brought it before the court are are not competent. But without, you understand me, which is the point Leonard Sik was alluding to. But we don't know that. But now that the issue has been resolved, the Supreme Court has made pronouncement. It is conclusive. And that is what I believe all these agitations should now stop concerning the election.
No,
should now...
A point that I want to, because, we are involved. And there's no point... I think we all know that our system, is not functioning optimally. I mean, the service delivery intendment of what we call the judiciary in Nigeria, beyond the points that Wahab made, I think what the Supreme Court was also saying in that is, okay, let's take, it wasn't an issue, but lawyers made it an issue, created problem where there was none, In this judgment now, the Supreme Court says, okay, there are no super citizens in Nigeria, irrespective of where you are living.
Okay. In relation to Abuja, right?
Yeah, well, I'm just using that because I'm using that as an example to explain what exactly the Supreme Court was saying there. So, I said the other time that it's a policy court.
Yeah.
So the decision is not meant only for, it's not restricted
just for that case.
For that particular case. It's meant to take your lesson from it. This is the law. We are laying down the law. So in this one, that was not an issue, but lawyers certainly created it as an issue and made it. In this case now, the Supreme Court says we all know that that's the law anyway, but some lawyers decided to, that you don't have super citizens anywhere in Nigeria. We are all equal in our rights. So take that as a policy decision of the court. Now, another lawyer or another litigant pays another lawyer to file a case to go and argue again that there are super citizens in Isaleko, in Lagos. You understand? That's ridiculous. Because you know that when you get to the Supreme Court, they are still going to repeat this same thing.
Yes.
So what the court is saying there is telling us lawyers that when you know that a policy has been laid down at that level by the Supreme Court applicable to what your client is asking you to go and do in court, why don't you simply tell your client that, look, there's a decision on this thing. It won't work. Look for another reason to come and, argue your case. Don't bring this here. In other jurisdiction, if a lawyer behaves that way, it's considered professional misconduct, actually. Wow. Yes, the lawyer will be dealt with. But in our own system here, we still permit, so that when you take the law reports, take Ghanaian's law reports, you see repetition. What the Supreme Court has said in 1960, it has not changed.
The law is still the law.
The lawyers will still take it to the Supreme Court in 2003. The Supreme Court will repeat the same thing. That way, you clog the system. There's no new issue you are bringing, no fresh issue that will excite anybody for the Supreme Court to make pronouncements on. What they have said 20, 30 years ago is what we are saying. So what the court is telling us, lawyers, stop. Go and look for something else to do. Don't come here and be disturbing this court with the same thing over and over again.
Okay.
You are bringing an issue here. We have made it. This issue that you have brought here, we've made a decision in so case saying that this is the law. You are still coming here to say we should do the same thing. So it's a warning. And I think lawyers we know that we should, this is not condemning anybody. And in any case, what I was saying the other time, that it's impossible for petitioner. It's easier for a respondent to win than petitioner. So lawyers that are representing petitioners have, it's not the same task. The task is too much. The time available to them, the evidence they have to look for. So for anybody who is not involved to say, oh, the lawyers for the petitioners didn't do a good job, I think the person has not been involved in the whole process. Obviously. But that's that. I'm talking generally now about policies of the court. Once the court has said this is the law on this issue, stop it. Don't go.
As they say, bam. Mr. Shitu. But the former vice president and Mr. Obi have said clearly that they do not accept this judgment.
If they say they do not accept this judgment, that would be very strange. Because you cannot practice democracy if you are not prepared to be a Democrat. And when we are talking of the fundamentals of the democratic tradition, all of us should be aware of it. What are the fundamentals? Respect for constitutionalism, respect for rule of law, respect for sanctity of the electoral process, and then independence and autonomy of the judiciary. Those are. So if you say you are running for an election under a democratic dispensation, and then you contested an election, and the umpire said you lost,
Be prepared to accept.
And you felt aggrieved about the pronouncement of the umpire, and you litigated the matter in court. And the highest court said, you lost.
Go home.
What you should do as a Democrat at that stage is to accept defeat, congratulate the winner, and then wait for another time. If you are a Democrat, and then you are operating under a democratic dispensation, you cannot say you do not accept the decision of the highest court of the land. The alternative to that is anarchy. And then we shouldn't encourage that. I have not heard them say so.
I don't think they say so.
I think their political parties have put out a statement either way.
Those political parties are probably not functioning under a democratic
but they ran.
No, not to be very frank.
Yeah, but the Americans have a beautiful way of putting court judgments. We call it judgment here. Over there, they call it opinion.
Oh,
yes.
It's only an opinion.
Yes, opinion.
Okay.
Opinion of the, So a judgment really is an opinion that has the force of law behind it. I can have an opinion.
Contrary to
the
his...
spokesman for Atiku may have opinion. The spokesman for Obi may have opinion, the spokesman for Tinubu may have his own opinion, but their own opinion have no force of law. The opinion in this case rendered by the Supreme Court has a force of law behind it. And there's nothing wrong in a democracy, for somebody to have his opinion and say, well, I disagree with what the Supreme Court has said. I think it's within their right to say so. Even
though they can't do anything about it.
They can say so. There's no big deal about it.
So how does that directly or indirectly affect how people take it and patriotism? Because the challenge is, I think one of you was talking about the sentiments and all that people bring into these things. And so long as people believe that, okay, this political party is saying what I believe, even whether they are right or they are wrong, their lawyers went to court and all those things. How does that affect?
If our democracy is affected by that, then it shows how weak that democracy is. Democracy should not be afraid of opinions. People can express their opinion. I have a right to say, for instance, I disagree with the decision of the Supreme Court. It's mine. I've assessed it, and I say that's not what I'm saying here. But if I say so,
well, within your right.
It's within my right to say so. If I say I disagree, so if as a litigant before the court you say you disagree, that shouldn't be taken as anything extraordinary. They disagree. It doesn't, as long as they have not taken up cordials or whatever, what will not take, for instance, what will not be right is for you to say, oh, these are the judges that gave this opinion, these are their phone numbers, these are the names of their children, begin to bombard them, and so on and so forth.
We heard that happen.
That would be wrong. But for simply saying, well, we've had the courts, we don't agree with what the court has said in this instance, it doesn't mean that they've done anything untoward. It's a democracy, they can say so. Their opinion changes nothing in this instance, but they have a right to disagree.
They have a right to express the opinion.
Yes, this is my opinion. And the lawyers that are also commenting, saying that they disagree, they won't say so just like that. They will give their reasons, and you'll see that they've been giving their reasons that, okay, what they are telling you is that if I were to be in the position of Justice Okoro, I won't do it the way Justice Okoro did it. I will do it this or that way. But the person is not in the position of Justice Okoro, so it's neither here nor there. Justice Okoro has made this pronouncement. That's the end of it. So that's the end of it.
Except to add that what the Supreme Court has handed down by way of judgment is a restatement of the law that we all know. It's a restatement, and I think that point must not be lost. We all, as lawyers, we have access to the Constitution, we have access to the Electoral Act. We know the rules guiding the conduct of elections. And we know that the judges have merely restated the law the way it should be. There's no way you can fault the judgment of the Supreme Court on any parameter. And that's why I'm saying that when you want to critique a judgment, it must be on the basis of the doctrine of justification.
Okay. Let me ask you this, because we have about 3 minutes to go.
Yeah.
Education for people about the judicial process and electoral contestations and all. How do you think this process, from the ruling of the appeal court or the presidential tribunal and this Supreme Court judgment, how much of education do you think has been given to people to help them appreciate what we've gone through?
For instance, I'm very, very much impressed by the decision of the Presidential Appeal Tribunal and the Supreme Court to televise the proceedings, the judgment, so that you can see clearly that the judice works on the basis of facts as adduced. The judice works on the basis of proof of facts as adduced, and inferences and conclusions arising from those proofs. And it has also sent a signal to local and international observers that the judice was, in this case, impartial. They dealt with the issues as presented. When they saw loophole, they highlighted those loopholes. When they saw the strength of guy, cases presented, also highlighted. That is some form of education. I think Nigerians, locally and internationally, are better informed about how the judice functions. So the judice does not function on the basis of beer parlor gossips, on the basis of sentiments, on the basis of public opinions. So, and let me give you just one example and close this. If, for instance, all of us witness murder being committed right before us here by someone who is later arraigned for such murder, and all of us, the four of us, refuse to go to court to give evidence of what we saw, what we witnessed, do you expect the Judas who was not there to now manufacture
evidence
to say, oh, indeed there was murder? And then you now go to, yes, can't we see that there was murder? Did you go to give evidence? Did you adduce the fact of that murder before the Judas? They don't work on sentiments.
Okay.
They work on facts as adduced within the parameters of the law.
Yeah.
I congratulate our Judas, and I'm proud. We have perhaps the best Judas in the Commonwealth. The best Judas in the Commonwealth. And my letter will agree that our Judas cannot be. And I think we should invest faith.
It cannot be faulted in this case.
And invest faith in our Judas.
Okay. Your closing comments on that same question.
The only thing I would say is that we've been talking about public opinion, and public opinion is not something that exists outside what the public is fed with. We influence people in different ways to believe, is the information made available to them. And I'll just use one good example here. A lot of our people, I don't want to go into the details of who is right, who is wrong. It's really none of my business. I have no stake in who becomes president. I went to vote. Whoever won, I don't give it.
My friends should have a stake.
No, what I mean is that in this contest, whether it's this person or that person, whatever, it's none of. I have no particular interest in who, But as a lawyer, take the issue of Abuja. It started as a joke. When it was first raised, I thought it was a joke. How can anybody be reasoning this way? Who is a lawyer? How can Now, if a lawyer is reasoning that way and is putting it out to the public, and these are senior lawyers, we call them senior advocates and so on and so forth, the ordinary person on the streets, would say, if this person is saying these things, there must be something, some merit in it. Maybe there's some kind of arguments in it and all that. Gradually, you find opinion coalescing to say, okay, because, if you really want your candidate to win, you are invested so much, personally invested in a particular candidate, you look for any reason why you should win. And when you have people who should know better giving you arguments that are really not arguments, you cling onto it and say, okay, with this, we can, get back this victory. The VP candidate of the PDP, for instance, well respected, an achiever in his own right and so on and so forth. I follow some of his statements. Owns a university, has a law faculty with, highly trained lawyers there. One would have expected him, for instance, to, take the free benefit of professors in his to this question, even if it is not as a citizen you cannot understand. I read his statement and I said, oh, thank God, Abuja saved Nigeria from an imminent disaster. And I was wondering, how can anybody be talking like this? But it was the information put out there that made a lot of people to begin to believe, contrary to their own, what should be reasonable to them, that nobody in Nigeria can say I'm super, I'm special, because I'm living in a particular place, Wow. It wasn't an argument that should even arise. But you saw that, a significant section of our country, began to believe in that, and they held on to it because they were invested in a particular candidate or in a particular outcome. I think that it's our responsibility when we are those who say they are educated or who have better opinion and all that, when we should understand that what we say, they have impact, they have implications. And we should always, for the sake of our country, irrespective of who we are supporting, who we are not supporting, we should be cautious in the things we do, in the things we say, so that we don't cause, unnecessary. And when you are talking of erosion, there are still some out there, erosion of confidence in the system. Yeah. There are still some out there, lawyers too, who will still say, well, Justice Okoro said there are no super citizens in Nigeria. If I were in Justice Okoro's situation, I would say there are super citizens in Nigeria. There are still people out there. So I think we should become
very interesting. We are completely out of time.
Let me just mention one.
Okay.
There's one other lesson that came out of this judgment is that if you want to prove that an election was rigged, adduce evidence from the polling units by people who witnessed the alleged irregularities, collation agents, or some other fresh evidence.
I think we need what do I call it now? We need the National Symposium on lessons from the Supreme Court. I have to thank you very much, gentlemen. Mr. Wahab Shitu is a senior advocate of Nigeria. Thank you so much for your time this morning. Also, a senior advocate of Nigeria, Yinka Olumide Fushika. Thank you so much. Very instructive conversation. So Sunrise returns right after now for another conversation. Stay with us.